The content provided in the CoTrackPro podcast is for informational and educational purposes only and should not be construed as legal, medical, or psychological advice. CoTrackPro does not provide legal representation or therapy, and the information shared is not a substitute for professional guidance tailored to your specific situation. Any views or opinions expressed by guests or hosts are their own and do not necessarily reflect those of CoTrackPro or its affiliates. While we strive to keep the information accurate and up to date, laws and policies may change, and CoTrackPro assumes no responsibility for errors, omissions, or outcomes resulting from the use of this content. By listening to this podcast, you agree that CoTrackPro, its team, and any affiliated individuals are not liable for any decisions made or actions taken based on the information provided. If you are facing legal, mental health, or family-related issues, please consult with a licensed professional in your area.
Welcome to the Deep Dive. Today, we're getting into something that can feel pretty overwhelming, finding your way through St. Louis County Family Court.
Yeah, it definitely can be.
We're using this really interesting resource. It's called the Family Court Quiz Game, kind of as our guide.
Right, and this isn't just, random questions. It's based directly on the local court rules. That's the 21st Judicial Circuit and also Missouri State Law, Chapter 452 specifically.
So our goal here is to pull out the really key stuff, how things work procedurally, what the laws actually say, and importantly, how orders get enforced, especially helpful if you're navigating this yourself without a lawyer.
Absolutely. It can seem like a maze, like you said. We want to try and shed some light, provide some clarity based on these official sources.
And it's worth saying, family court deals with really personal, often difficult situations. We're not giving legal advice here.
Definitely not. We're just aiming to make the process, the system, a bit more understandable using the information we've got.
Okay, let's dive in. First up, just the basics. What is the family court in St. Louis County?
So it's the specific court that handles all the family law stuff. Think divorce, child custody battles, figuring out paternity. That's its focus.
Right, the dedicated place for those issues. And who's kind of running the show behind the scenes administratively?
Well, there's the court administrator. They're basically the chief admin for each court division, making sure the operational side runs smoothly.
And if you, the litigant, need to file something or ask about your case files, who do you talk to?
That's usually going to be the court administrator or the court clerk. They manage the documents, the case files, and they're often the conduit for communication, between you and the judge's office.
Okay. And it's good to know what doesn't go there, right?
Yeah, exactly. Like a traffic ticket, totally different court. Family court sticks to the family and domestic relations side of things.
Gotcha. And when kids are involved, especially in what they call juvenile matters.
Oh, yeah. There's a specific role there.
Mm-hmm.
The chief juvenile officer. They oversee those cases within the family court structure. Very important role.
Okay, let's shift to actually starting a case. Filing documents, making those formal statements. I think they call them pleadings.
Pleadings, right. And if you're filing for divorce in Missouri, the source material is really clear on a couple of things you must include in that first document, the petition.
Okay, what are they? This sounds critical.
It is. You absolutely have to include a proposed parenting plan. That's your suggestion for custody, visitation, decision-making, all that. And Social Security numbers for everyone involved, not optional.
Wow. Okay. Good to know. And what about when a document needs to be verified? What does that mean exactly?
Yeah, verified means you have to swear that it's true. And you can't just, sign it anywhere. It needs to be done in front of a notary public. You take an oath.
Oh, it adds that formal legal weight, huh?
Precisely.
And we mentioned representing yourself. What's the official term for that again?
That's called being a pro se litigant. P-R-O-S-E. Just means you're acting as your own lawyer, basically.
Okay. And court documents always have that heading at the top, the caption. Is there a specific way that needs to look for a divorce?
Yes, there is. For a divorce case, the correct caption is, in re the marriage of name and name. That's the standard format. In re just means in the matter of.
All right, so you file the petition. What if the other person just sets ghosts, doesn't respond at all?
Well, that's a risk for them. If they fail to file an answer within the deadline, the court can potentially issue something called a default judgment.
Meaning the court might just make decisions based on what the first person asked for.
Essentially, yeah. It means decisions could be made without their input because they didn't participate.
Okay, that leads right into enforcement. You get a custody order, but how do you make sure it's followed?
Right, that's where the law comes in. Specifically, Missouri Revised Statutes, Chapter 452. That chapter lays out the rules for enforcing custody and visitation orders.
So, say one parent isn't following the schedule. What can the other parent do?
Generally, a couple of main routes. You can file a motion for contempt with the court, asking the judge to step in, or sometimes you might involve law enforcement.
Ah, okay. Involving the police. How does that work? Can they just show up and enforce the order?
Here's the crucial part. Only if there's a clear, valid, written court order. They need to see that official paper.
So a verbal agreement, even if everyone knows about it?
Nope. Doesn't count for police enforcement. They need the actual court document. It has to be unambiguous.
That is super important for people to understand. No written order, no police enforcement for custody or visitation.
Exactly. Keep that paperwork handy.
What about orders from other states? Can Missouri enforce those temporarily?
Yeah, interestingly, the law allows for that in urgent situations. Even if Missouri doesn't have long-term jurisdiction, a court here can issue a temporary order to uphold another state's order if, say, a child is here and needs immediate protection based on that out-of-state ruling.
Okay, interesting. Let's talk about some other steps in the process. Parent education.
Oh, yeah. If kids are involved in a divorce or custody case in St. Louis County, get ready for parent education classes. Our source says they are absolutely mandatory.
Not just recommended, but required.
Required. And
Yeah.
You don't just attend, you have to prove it. You file a certificate of completion along with your parenting plan. It's part of the package deal.
Okay. Now, I've heard of something called the automatic family court order. What's that about?
Right. The automatic order kicks in basically right when a case is filed. Its main job is to keep things stable, preserve the status quo financially, and regarding living situations.
So, like, prevents someone from suddenly draining bank accounts or moving the kids out of state?
Exactly. No big unilateral moves without the court's permission first. And violating it is a big deal. Could lead to contempt charges, sanctions.
Okay, so rather than jumping straight into court fights, is there an alternative? Like mediation?
Yes, mediation is heavily encouraged. The whole point is to get the parties talking, trying to reach their own agreements on parenting time, support, the key issues, ideally without needing a judge to decide everything for them.
Makes sense. Now, in court, you might deal with someone called a family court commissioner. Are they the same as a judge?
Good question. They handle a lot of the day-to-day case management, hearings, and can make recommendations. But, and this is key, they cannot issue the final judgment. Only a judge can do that.
Got it. And back to the administrative side, who oversees the chief juvenile officer we mentioned earlier.
That falls under the family court administrator. They supervise the chief juvenile officer. Shows how the different roles connect.
Okay. And even if the other side defaults, doesn't show up for a custody hearing, do you still need that parent education certificate filed?
Yep. The source says even for a default hearing in a custody case, that certificate needs to be on file. The court wants that baseline education completed.
And money matters, child support, expenses. What does the court need before ordering payments?
They need the numbers. You have to submit a detailed financial statement. Income, expenses, assets, debts, plus proof of child-related costs like daycare or insurance bills. Can't just pull numbers out of thin air.
Right. And this whole process of exchanging information before trial? Discovery. What if you don't follow the rules there?
Discovery. Yeah, that's the formal process. If you ignore the rules, miss deadlines, don't provide documents you're supposed to, the court can impose sanctions. Could mean fines, or even preventing you from using certain evidence. You got to take it seriously.
Definitely. Okay, so what if someone isn't following an order? We mentioned contempt earlier. Let's dig into that.
Right, the motion for contempt. That's the tool you use specifically to ask the court to enforce its own order when someone's ignoring it.
Is it enough just to say they're not following it?
No, there's a burden of proof. At the contempt hearing, you have to show the judge that the other person willfully disobeyed, meaning they knew about the order, they had the ability to follow it, and they consciously chose not to.
Okay, willfully is the key word there. And if the judge agrees, finds them in contempt, what happens?
Consequences can range. Could be a fine, could be, in more serious or repeated cases, jail time. It shows the court means business about its orders.
How do you even start that process? Requesting a contempt hearing.
You need to file a verified affidavit. That's a sworn statement, signed in front of a notary, detailing exactly how the order was violated. Again, formal, specific, under oath.
And is contempt always the same? Or are there different types?
The judge decides if it's civil contempt or criminal contempt. Civil contempt is usually about coercing compliance, getting the person to do the thing they were ordered to do. Criminal contempt is more about punishment for disrespecting the court's authority. The judge makes that call.
Interesting distinction. Okay, what about cases where everyone agrees, an uncontested case? Do you still have to show up for the final hearing?
Usually, yes. Even if everything's agreed upon, the petitioner, the one who started the case, generally still needs to appear and give some basic testimony to the judge to finalize everything.
And in a default case, where the other side never responded, can the judge finalize things then?
Yes, but only if there's solid proof that the respondent was properly served with the initial lawsuit papers and still didn't answer. The court has to be sure they had their chance to respond. Due process.
And a big one for people used to other courts. Are there juries in family court?
Nope, no juries. All decisions, custody, support, property division are made by the judge alone. Bench trials only.
Okay, so if you are heading to a contested hearing where you disagree on stuff like custody or support, what financial info does the judge need beforehand?
Before any contested hearing on those issues, both sides typically have to file up-to-date income and expense statements. The judge needs that current financial snapshot to make rulings.
And the final decision, it's based on everything filed, plus what happens in court.
Exactly. The final orders will be based on the live testimony, what people say under oath on the stand, and any exhibits, any evidence that's formally admitted during the hearing.
Let's talk more about those finances. Why does Missouri require financial disclosure in the first place?
It's fundamental. The court needs that income, assets, debts to make fair decisions about child support, possibly spousal support or maintenance, and how to divide any property the couple acquired during the marriage.
And one specific document for that is the marital property statement.
Yes, that's a key one. It lists out all the assets and debts considered marital property, which is usually stuff acquired from the date of marriage to the date of separation or divorce.
What about child support timing? Can it start from way back when the case was first filed?
It potentially can, yes. The court has the authority to make child support orders retroactive, often back to the date the petition was filed, so that obligation might start accruing before the final order is even signed.
And maintenance alimony, can that just stop automatically sometimes?
Yes, there are triggers. A common one is if the person receiving maintenance payments remarries. Under Missouri law, that often automatically terminates the obligation to pay.
In dividing up property, is it always 50-50?
Not necessarily. The standard in Missouri is fair and equitable division of marital property. That might be 50-50, but the court can consider various factors and decide on a different split if that's deemed more fair in that specific situation.
Okay, let's switch gears to something really serious. Protective orders. What law covers those?
That's Missouri Revised Statutes, Chapter 455. It deals with orders of protection related to domestic violence, stalking, and abuse. Very important statute.
How long does a full order of protection last?
A full order after a hearing can last up to 1 year initially. But crucially, it can often be renewed if the danger or harassment continues, so it's not always just for 1 year.
If someone needs to file for one in St. Louis County and they don't have a lawyer, where do they go?
The source points to the Adult Abuse Office. That's a key resource for self-represented individuals needing help with the paperwork and process for getting an order of protection.
I've heard of temporary orders, like ex parte orders. How do those work?
Right, an ex parte order is temporary, granted quickly, without the other side present initially. But to get one, you have to convince the judge there's an immediate and present danger of abuse. It's a high bar because it affects someone's rights without them having a chance to respond yet.
And if someone violates an order of protection?
That's incredibly serious. It's not just a family court issue then. It can lead to criminal charges, arrest, prosecution, the whole 9 yards.
Okay. What about police reports? Can you use those in family court?
You definitely can submit them. They can be used to show alleged violations of court orders, like custody interference, or to document incidents relevant to the case, like abuse allegations.
Does any police report work, or does it need to be specific?
For it to have real impact, yeah, it should be an official report specific to the event you're trying to prove. A detailed narrative from the officer carries more weight than just, a call log.
So if you do call the police about a custody issue, what should you have ready?
Absolutely. Have your written court order with you. Show it to the officers. That gives them the legal context for what's happening.
Can the police actually arrest a parent for messing with custody?
They potentially can, yes, if the interference rises to the level of a criminal offense under Missouri law. like parental kidnapping or specific types of custodial interference defined in the criminal code.
But just having a police report doesn't automatically change the custody order itself, right?
Correct. That's a vital distinction. The police report is evidence for court. To actually change the custody schedule or arrangement, you need to file a motion to modify with the judge and present that report, along with other evidence, in court. The report alone doesn't do it.
Makes sense. Okay, parenting plans. We mentioned them earlier. Is there a deadline to file one?
Generally, yes. If you've been served in a case involving kids, you typically need to file your proposed parenting plan within 30 days after that service.
And what kind of details need to be in there?
It needs to be practical. Things like who transports the kids for visitation, how holidays and school breaks are split up, and really importantly, who gets to make the major decisions: education, healthcare, religion, that kind of stuff. Legal custody decisions.
What if parents just can't agree on a plan?
Then the court steps in. There'll likely be a hearing, maybe mediation first, but ultimately, if they can agree, the judge will hear both sides and issue an order, maybe a temporary one first, setting out the plan.
Can you clarify legal custody? What does that actually mean?
Legal custody is about the decision-making authority, who gets the final say, or how decisions are made jointly regarding the child's major life aspects: health, schooling, general welfare. It's separate from physical custody, which is about where the child lives primarily.
And what if one parent just doesn't file a plan, blows it off?
The court won't just ignore it. The judge might then look more favorably on the plan the other parent submitted, or the judge could even create their own plan based on what they think is best for the child, using the evidence they have.
Okay, let's talk child support calculations. How does Missouri figure that out?
They use a specific worksheet. It's called Form 14. It's a standardized calculation that plugs in parents' incomes, costs like health insurance and daycare, overnight visitation schedules, and spits out a presumed child support amount.
Is that amount set in stone forever?
No, it can be modified, but you need a good reason. Usually it requires showing a substantial and continuing change in circumstances, like a major job loss or a big promotion, or the child's needs changing significantly, not just minor fluctuations.
And can changes also be retroactive, like the initial order?
Yes, modifications can often be made retroactive, typically back to the date the motion to modify was filed.
If someone isn't paying, how does the state or the other parent collect?
There are several enforcement tools. Wage garnishment is common, taking it directly from their paycheck, intercepting tax refunds, both state and federal, suspending driver's licenses or professional licenses, even contempt proceedings leading to jail time in some cases.
Who actually does the enforcing?
It can be the court itself, through contempt motions. And also, Missouri has the Family Support Division, a state agency specifically tasked with establishing and enforcing child support orders. So, multiple avenues.
Got it. Let's get into some court procedures. E-filing, is that mandatory for everyone?
For attorneys, generally yes. But for self-represented litigants, pro se parties, our source indicates they are usually exempt from mandatory e-filing in St. Louis County Family Court.
Are there exceptions?
Yes. The rules can be complex. Things like small claims or those Chapter 455 protective order cases might have different e-filing requirements or options, so you need to check the specifics for those case types.
Can you file by fax if you're pro se?
Sometimes. The rule mentioned in our source suggests it might be allowed if the document is short, under 10 pages, and it's not the very first petition starting the case. But always best to check with the clerk.
Being pro se doesn't mean you can ignore the rules, though, right?
Absolutely not. You're held to the same standard as an attorney in terms of following court rules, procedures, and deadlines. Ignorance of the rule isn't usually an excuse.
And protecting private info, like social security numbers.
Critical. Any confidential information like SSNs, bank account numbers, etc. must be redacted, blacked out on any documents filed with the court that become public record. There are specific rules about how to do this.
How should you communicate with the judge if you need to? Can you just call their chambers?
No, definitely not direct contact like that. Proper communication is through formal, written motions filed with a clerk, or sometimes through the court clerk's office for procedural questions. You don't want any ex parte communication talking to the judge without the other side present.
And in the courtroom, how do you address the judge?
Always, Your Honor. It's the standard sign of respect for the position and the court.
What about dress code? What should people wear?
Think business casual or modest everyday wear. No need for a three-piece suit necessarily, but avoid shorts, tank tops, hats, anything too revealing or distracting. Show respect for the setting.
Can you talk in court?
Only when you're supposed to. like when the judge asks you a question, or when it's your turn to present your case or question a witness. Don't just chat or interrupt otherwise.
What happens if you're late or just miss your hearing time?
That can be disastrous. The court might dismiss your case if you're the petitioner, or issue orders against you if you're the respondent. They won't necessarily wait. Punctuality is vital.
Let's clarify some legal terms. What exactly is a motion?
Simply put, it's a written request asking the court to do something specific. Rule on an issue, grant some relief, schedule a hearing. It's how you ask the court to take action.
And if you want to change an existing custody or support order,
You have to file a specific type of motion, called a motion to modify. You can't just informally ask. It requires that formal legal request outlining the changed circumstances.
we mentioned show cause hearings earlier in relation to contempt.
Right. A show cause hearing is basically the court ordering someone to appear and explain why they shouldn't be held in contempt, or why some other action shouldn't be taken against them. They have to show cause for their actions or inaction.
What about a motion for summary judgment? Sounds complicated.
It can be. It's a request asking the judge to decide the case, or parts of it, without a full trial. You argue there are no real factual disputes, and based on the undisputed facts and the law, you should win automatically. It requires strong evidence and a written legal brief.
And if you file a motion, but don't tell the other side?
Big problem. Yeah. You must properly serve the other party with a copy of any motion you file.
Yeah.
If they don't get notice, the court legally cannot consider your request because the other side hasn't had a chance to respond. It violates due process.
Okay. Let's talk about guardians ad litem GALs. What's their role?
The GAL is appointed by the court specifically to represent the best interests of the child in the case. They're like the child's lawyer, but focused solely on what's best for the child, not necessarily what the child wants or what the parents want.
When are they typically appointed?
Often in high-conflict custody cases, or especially when there are allegations of abuse or neglect. The judge appoints them when they feel the child needs an independent voice.
Who can be a GAL?
In Missouri, our source indicates a GAL must be a licensed attorney. They need that legal training. What do they actually do?
They investigate. They'll talk to the parents, the kids, if old enough, maybe teachers, doctors, therapists. Then they usually write a report for the judge with recommendations about custody, visitation, services needed.
What if a parent disagrees strongly with a GAL's recommendation?
They can challenge it. You typically file a written objection with the court explaining why you disagree, and then present your own evidence and arguments at the hearing to counter the GAL's report.
You can cross-examine the GAL too.
Okay, moving towards juvenile court issues. What kind of cases end up there?
Juvenile court handles cases specifically involving minors. This includes abuse and neglect allegations, status offenses, and delinquency, which is when a minor commits an act that would be a crime if done by an adult.
What's a status offense again?
That's something illegal, only because the person doing it is a minor. Things like skipping school, truancy, violating curfew, running away from home.
Does the child get representation in juvenile court?
Yes, often. A child might have a GAL appointed, like in family court, or they might have a juvenile officer assigned to their case. Sometimes both. They might also have their own separate attorney.
If custody needs to be transferred in a juvenile case,
That's a significant decision and has to be formally approved by the juvenile court judge. It's not something parents or even the Children's Division can just decide on their own if the court has jurisdiction.
who can start an abuse or neglect case? Is it just the parents?
Oh, no. Many people can. Teachers, doctors, therapists are often mandated reporters. A GAL, a juvenile officer, even concerned relatives can initiate a report that might lead to a case.
All right, let's talk evidence for trial. What makes something admissible?
Two main things: relevance and admissibility under the rules of evidence. It has to relate directly to the issues the court is deciding, and it can't violate rules like hearsay or proper authentication.
What about texts, emails, photos? Can you use those?
Yes, potentially. Digital evidence is common now, but you have to authenticate it, prove it's real, and hasn't been tampered with, and it still has to be relevant. Just having an angry text isn't enough if it doesn't relate to a legal issue like custody factors.
Witnesses. Can you bring anyone to testify?
You can call witnesses whose testimony supports your case, yes. But you generally have to disclose who your witnesses will be to the other side before the hearing. No trial by ambush. And their testimony still needs to be relevant and follow evidence rules.
What about expert witnesses, like a psychologist?
If you plan to use an expert, you almost always have to disclose them well in advance during discovery, provide their reports, and potentially make them available for deposition by the other side. It's a formal process.
And if you mess up the deadlines for providing evidence or witness lists,
The judge can impose sanctions. That might mean you don't get to use that evidence or call that witness at trial. It underscores the importance of following the court's scheduling orders.
after the trial, what's the judge's final decision called?
It's usually called a judgment or an order. It's the official written ruling that resolves the issues in the case.
Can that final order ever be changed?
Yes, custody and support orders can usually be modified later, but again, you need to file a motion to modify and prove the substantial and continuing change in circumstances we talked about earlier. Property division in a divorce decree is generally final, though.
How do you get a copy of the final judgment?
You can usually get a copy from the court clerk's office. You might have to pay a small fee for copying. Or sometimes it's available through online court portals, if applicable. A form of records request also works.
If you think the judge made a legal mistake, where do you appeal?
Appeals from St. Louis County Family Court decisions go to the Missouri Court of Appeals, usually the Eastern District.
Is there a deadline for appealing?
Yes, a strict one. You typically have only 30 days from the date the final judgment is entered to file your notice of appeal. Miss that deadline, and you likely lose your right to appeal.
Okay, quick recap on a few terms. Pro se, again.
Means representing yourself, no lawyer.
Are family court hearings public?
Generally, yes, but cases involving juveniles or abuse neglect details are often closed to protect the children involved.
And consequences for not paying child support. We covered some, but recap.
Wage garnishment, tax refund interception, license suspension, driver's professional, contempt of court leading to fines or jail, negative credit reporting, lots of tools.
Before a trial, might the judge make you attend something else?
Yes, often a pretrial conference or a settlement conference. The judge tries to get the parties to narrow the issues, stipulate to agreed facts, or maybe even settle the whole case before trial.
And mediation it's always required.
In St. Louis County, our source suggests it's generally mandatory in contested custody or visitation cases. The court really wants parents to try and work things out themselves first.
So wrapping this up, after diving deep into this family court quiz game material about St. Louis County, what are the big takeaways for someone listening, maybe someone facing this themselves?
Well, I think it's clear that understanding the basic structure, who does what, the different roles is huge.
Right.
Knowing the rules for filing things correctly, what needs to be included, like in that divorce petition. That's crucial.
But yeah, and knowing how things get enforced, like needing that written order for police or how contempt works, that practical side is really important.
Absolutely. And for anyone going pro se, just knowing the terminology, the right way to file a motion, understanding what verified means, it's all foundational. It demystifies it a bit.
This quiz game format, even though it sounds maybe a bit dry, it really does highlight the specific rules and laws right there in St. Louis County. It's like a targeted study guide.
It really is.
Yeah.
Which brings us to maybe a final thought for you, the listener.
Yeah.
Think about the power that comes from just understanding a complex system, right? Even when you're in a really tough personal spot. If you can start to unpack something like family court procedures, which seems so tangled, imagine where else in life getting a deeper understanding of complicated things, maybe work systems, financial stuff, whatever, might actually give you more clarity, maybe even more control than you thought. Something to think about.
Thanks for listening to the CoTrackPro podcast, where families come first and technology bridges the gap. If today's episode helped you better understand how to navigate co-parenting, protect your rights, or support your child's well-being, we invite you to explore our full suite of tools at CoTrackPro.com. Subscribe, leave us a review, and share this episode with someone who needs it. You're not alone, and with CoTrackPro, you're backed by purpose-built apps that help families make better decisions, stay safe, and move forward. Until next time, take care of yourself and each other.